Okay, so yeah, it looks like. Oh wow. Yeah, so it looks like the parties have just come into the courtroom. Um, that deputy that just came out from judge's chambers just went in there a minute ago. The judge walked him back. Not entirely sure what was going on with that. Um, okay, I had missed that they got actual jail time. I have to go back and double check. As I recall, there were, at least in Ponte's case, I believe there were um, some more significant charges involved, and now let me just go ahead then and since we got a minute while we're waiting for them to actually. Now, let me take a look at. Yeah, because we had Cooper and Kramer, and Kramer, or they both got double dockets. Let me. Da, 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 da. 3 years probation, 120 hours community service. Oops. That was that one. Okay, where I'm jumping between different cases, it's possible that I misread. That's what I'm trying to look. So yeah, Cooper looks like only got probation and community service. His second case was fully dismissed. Let me look at Kramer. That's the other one that I would have thought was the patrons at Cider Riot. None of them were charged, and at this point, we are past statute of limitations for anyone there to be charged with anything. Let's see. Okay, so Kramer. 5 years probation. Not participating in any unlawful assembly. Oh. No, he actually had 20 months of incarceration. Wait. Sorry, the court considers this 20-month sentence to be time already served. But he had assault to and unlawful use of a weapon, as well as then that would have been the separate riot charge, which I'm going back and double checking.
All rise.
Good afternoon, everyone. Well, welcome to have a seat. We'll go on the record. Mr. Kalbaugh.
Your Honor, we're here in the matter of State v. Lewis, case number 19 CR 53040. This is the time and place for sentencing after a jury came back with a verdict of guilty. Representing the state of Oregon, Brad Kalbaugh, Kalbaugh, bar number 074335. I have co-counsel to my left, defendants present, out of custody, represented by counsel.
Mr. Kalbaugh, thank you.
Morning, Your Honor, or good afternoon, Your Honor. Also for the state, Sean Hughey, Hughey, bar number 152776.
Mr. Hughey, thank you. Mr. Doyle, good afternoon.
Good afternoon, Your Honor. Kelly Doyle, 840394, and that's Doyle.
Thank you. Is Mr. Lewis ready to proceed?
Yes, Your Honor.
Thank you, Mr. Doyle. Mr. Lewis, good afternoon, sir. You're welcome to have a seat. Mr. Kalbaugh.
Your Honor, the state submitted a sentencing memorandum. It's very brief and really it just summarizes the Oregon administrative rules and the laws there. There's nothing, there's no remarkable arguments based on any authority in there. We're just making sure that the legal authority for the sentencing that brings us here today is clear and clear for the record.
Thank you.
So this is a presumptive probation sentence based on the defendants having no prior felony convictions and no Class A misdemeanor convictions on his record as of today. He is an I on the guidelines grid. Therefore, as a 6, this is Riot is a level 6 on the guidelines grid. As a 6I, we are asking you to give him the presumptive term of probation, which would be 3 years of probation. We are asking that as a condition of probation, he do 30 days in jail. As the guidelines, he could do up to 90, but you would have to make a finding that there's space available. We think that the presumptive amount of 30 is appropriate in this case for the reasons set forth in the record, which is mainly when looking at the crime of riot, we look at the harm to the community. When looking at the crime of, just as an example, robbery. Sometimes you have a robbery case and one might look at it and say, hey, this isn't a very serious robbery, someone only got $2. But the point of a robbery isn't whether you're successful or not. The point of the robbery would be the threatened use of force. And a burglary, if someone burglarizes someone's house and all they end up stealing is a broken cell phone, the point of the burglary is that it's a home invasion. That's the gravitas of the crime. And here, I know that there are other times that could have been charged. Your Honor discussed harassment when looking at Mr. Gibson's case, and certainly a harassment charge would have been supported by these facts as well, as would a misdemeanor disorderly conduct or other crimes. But the crime of riot is what was pled, and the jury did find this defendant guilty of riot. And looking at this riot, it did generate significant alarm within the community and 19 911 calls. So that's the reason that we think that the 30 days jail is appropriate. We also are asking for all the general conditions of probation to be imposed, and as well as that one special condition we did add, which I think should be sufficiently set forth there. That would be no participation or attendance at any unpermitted marches, protests, or demonstrations. Obviously, if they're permitted, then that's fine. But if they're unpermitted, there's a good chance that they may be violating some of the law anyway. So that would fall with bail laws.
Can I just ask a clarifying question about that request? Is the state's request that once an assembly is declared to be unlawful or there's a dispersal order from law enforcement, that at that point the condition would kick in and Mr. Lewis would have to leave, or that is the state's intent to the contrary, that Mr. Lewis may not sort of show up and participate if somebody who is there isn't holding a permit that allows?
I think if Your Honor were to clarify it that way, it would be easier for the defendant to know where the line is drawn. So that probably is a good clarifying means.
The back end clarification is
what the state's asking, because yes, we just want to make sure if there's a situation where everyone is out there doing something and it's getting out of hand, then there's not a permit for this, because if there's a permit, do it. That's protecting your constitutional rights. But once you're out there and there's no permit and it's gotten to the point of everyone telling you to leave, you should be on notice that the event you're attending isn't what it's supposed to be.
Okay, thank you, Mr. Kalbaugh. Mr. Doyle.
Your Honor, I just, I received this state sentencing memorandum as I walked into court. And I have, I believe the court had received some of my materials.
I assume those have been filed. I've received them directly, which I appreciate, Mr. Doyle. I assume they either have been filed or will be filed.
I just emailed everything both to you and to opposing counsel and everyone. I have not e-filed them.
Okay, would you like those materials also to be filed?
Yes.
Okay, any objection from the state for the court filing those?
No
Okay.
objection.
Thank you. We will get those on file. I have received them. I have looked at them.
I believe there's an earnings statement on there. Defense may want to consider redacting some personal information before they make it a public record, but we have no objection to them filing whatever they want.
Thank you, Mr. Kalbaugh.
And I'm not sure where to go because the unpermitted free speech that the state is requesting, it was one of the key issues in this case. And symbolic speech and key speech, in fact, 2 of the defendants were found not guilty of riot based upon free speech issues. If the court is going to be considering a prison sentence, jail sentence, even a minimal jail sentence, based upon our objections and the way the case was tried and the way the jury was selected. I think I am forced, because of this case, because of the free speech issues, because he was at a flag wave, which was a symbolic speech case. If we're going to even consider jail time, I'm going to have to request a sentencing set over, because I do not think that jail is at all, even a day in jail, is appropriate for this case.
You need to understand the basis for that request, Mr. Doyle. This was the time. I need to understand the basis for that request. This was the time set for sentencing.
I know, and this is and I just received this memorandum. We did not get any of the 9/11 calls, and because of the significant harm done by this defendant, I don't see this.
The harm done to this defendant, do you mean?
It says significant harm
Oh,
done
I'm sorry, you're
by-
quoting the state.
I'm quoting the
Very
state.
well.
I'm not quoting the defense, not at all.
Okay.
I'm not even near there.
Okay.
And we had requested lesser included, and those were denied. And the defendant is being sentenced for, all caps, screaming out riot. I think at least it could be caps in lowercase. There's some real severe free speech issues into their request. And apart from the jail time, and apart from what we've tried to endeavor to introduce, is that he is working full time. He has children that he's responsible for. He's in a committed marital relationship. All of these factors, I think, would mitigate, not even against jail time, but I think would be appropriate for probation with immediate misdemeanor treatment, so that he could get it off his record. But the state is taking a very strong adverse position to the defense's position. And based upon this memorandum, we would be requesting a set over.
Thank you, Mr. Doyle. The request for a set over is denied. Is there any additional argument you wish to make?
Yes, Your Honor. Mr. Lewis is working in as a plumber, apprentice. Haley is here in court and supporting her well, they've been married, but not, but they're together and they're working. And so I would request the court has heard what I would request as a sentence. And also, I would strongly worry about the state's special condition under the justification for jail, because what the state is requesting basically takes away all of his free speech rights. He did not go to this gathering as an intent to riot, and that was one of the joys of riot, as it was pled and whatever, is that part of it is a non-intentional crime. And so with the free speech issues, and of course as the court saw that he is, one of the reasons that this case was even brought is that the owner of the Cider Riot is suing both Mr. Gibson and my client for $1 million. And that was also a consideration. So I don't think I have too much more to say right now, Your Honor.
Mr. Doyle, thank you. Mr. Lewis, in Oregon, we have something called the right of allocution. It's your constitutional right. It's an acknowledgement that sentencing a defendant in a criminal case is a big deal. and a big enough deal that rather than simply relying on what your lawyer has to say, the person in your position should have the right to speak for himself. It's meant as an opportunity. It's not an obligation. I'm not going to punish you if there's nothing for not saying anything, if there's nothing you want to say. But if there is something you want to say, you have the right to say it, and separate and apart from your having the right, I'm very happy to listen. Is there something you'd like to tell me, sir?
Yes, sir.
Thank you. Please go ahead.
Thank you for this opportunity to speak. I would just ask you to not give me any jail time. I have a family that I care very deeply for. I have a career that I've been very passionate to get into. I'm a plumber's apprentice. I've spent many years trying to find my passion in what career I want. I've worked very hard to get here. I start my plumber's apprenticeship in September, and this career could be life-changing for me. I'm doing very well at my work. They really like my work and really rely and depend on me. And for me to go to jail, I just feel like I just don't understand how it's gonna make me a better person. It's gonna ruin my life. And I have to support my family, I have to support my kids, and I can't serve any jail time, Your Honor. So I'm just asking for your mercy. And that's all I have to say.
Thank you, Mr. Lewis. Anything else for the record?
No, Your Honor.
The court will turn to sentencing. I agree with the state's analysis that Mr. Lewis is a 6I on the grid that would call for a presumptive 3-year term of probation. To be clear, the state is asking for those 3 years, but as a condition of that probation, the state is also asking for 30 days in jail. So people sometimes get confused about those two different things happening at the same time, but the idea would be a 3-year, if the state gets what it wants, or what it is seeking, I beg your pardon, the idea would be a 3-year term of probation, but in addition to following the other rules of probation, obeying all laws and that sort of thing, that a condition would also be that Mr. Lewis serve 30 days. So that's what the state's request is. I understand Mr. Doyle is asking that this case be treated as a misdemeanor, presumably with a probation-only sentence. I don't want to sort of hide the ball, but there are a couple things I want to say quickly. The first is that I think one of the mistakes that we all make as humans, certainly I do it, is that we think the world is a very simple place and only one thing can be true. And that's not how the world is. The world is a more interesting place than that. The world is a more complex place than that. And in this case, as I look at sentencing Mr. Lewis for this crime that the jury found him guilty of, there are a lot of things that are obviously true all at the same time. One is that, as Mr. Lewis pointed out, he is working hard to support a family. It is clear he has many, many people who care about him and love him, which suggests to me he conducts much of his life as someone who is worthy of loving and being loved. We know this from the sentencing grid, and as the state acknowledged, Mr. Lewis has lived more than 30 years of his life without a criminal conviction. He has proved that he is largely able to follow the rules and is not running around as some inveterate lawbreaker. All of that is true, and it's important, and it matters when a court looks to sentence a defendant in Mr. Lewis's position. What is also true is that a jury found that Mr. Lewis, on May 1st, 2019, committed the crime of riot. That is to say that while participating with 5 or more other persons, he engaged in tumultuous and violent conduct, and that he thereby intentionally or recklessly created a grave risk of causing public alarm. Mr. Kalbaugh talked about the 19 911 calls that were in the record in this trial, and also, candidly, the video evidence demonstrates the alarm. I am keenly aware that Mr. Lewis is not accused of, and that there is no evidence that he physically hurt anybody. That's really important. But it's also important that the jury found that Mr. Lewis contributed in committing riot to an environment and to a situation where people got hurt, including someone getting hurt really pretty badly. At least one person getting hurt badly that we heard about. That's also really important. And what is so striking to me is that it was so unnecessary. I don't know, and I'm not asking you, Mr. Lewis, what you were trying to accomplish that day, but it is clear to me that you knew violence was possible or probable, even if it wasn't the plan. You were ready for it. You had your helmet, you had your gloves. And you contributed to that. The jury found that you engaged in that conduct, that you raised public alarm, and that public alarm was justified because somebody ended up getting hurt badly. And so on the one hand, you have lived this life of supporting people and being supported and working and being productive. I'm thrilled to hear that you are on a good path professionally, that you are pursuing something that you want. And I agree with you. Derailing you from that, I don't think helps anybody. At the same time, as the state's memorandum points out, this is a crime against the community, and this is the way the community pushes back when it has been wronged. This is how the community says this conduct is not acceptable. This is not within the rules. And so it was a bad choice. It's not a choice that has to define you, and I acknowledge it stands against what look like an awful lot of good choices. And all of that matters, and all of that goes in. I do not believe that 30 days in jail accomplishes, is what is required to accomplish the community's need to push back. I do think a short jail term is appropriate because of the gravity of the circumstance and because of your decision to be there and to participate. That decision has consequences. I think the appropriate consequence is the 3-year term of probation as identified by the state. And as a condition of that probation, a term of 3 days in jail. Those days can be served together or one at a time. They must be completed no later than November 1st of this year. Mr. Lewis will not be brought into custody today. He may turn himself in. I will need you to report to the sheriff's office and the Justice Center today just to check, or the jail, I should have said, just to check in with them. But you do not, Mr. Lewis does not need to go into custody today. He can work it around his schedule so that we don't derail him. I'm going to waive all fines or fees that might otherwise be imposed. Mr. Lewis has a family that he is taking care of. He is working hard to do that. I don't believe that the community is benefited by further taxing him with a financial penalty. Mr. Lewis, I'm not any kind of intellectual or emotional or spiritual leader of yours. I know that. I'm here because I have a job, and you're here because of this case. So I won't purport to try to teach you anything or give you wisdom. But what I will say is that it is clear to me you are capable of making good, productive choices that help those who love you and that you love. You have lived the majority of your life making those choices. This, I will categorize, was a bad choice. But it does not have to mean that from here on out you make bad choices, and I don't suspect that you will. I suspect that in 3 years your probation will be terminated as successful, and that this will be fully behind you, and you can go back to doing the work of supporting, focusing only on supporting those who love you and who you care about. So that will be the order. Is there anything else for the record?
Did Your Honor decide whether to
I'm
impose?
sorry. I beg your pardon, Mr. Kalbaugh. Thank you. As to the special condition, this is what I agree with Mr. Doyle that simply saying that Mr. Lewis cannot participate or attend at any unpermitted marches, protests, or demonstrations is too vague. It invites trouble for Mr. Lewis if he decides he wants to participate in something that is not violent. The idea that he would have to do research to find out whether it's permitted or not, I'm not going to impose that condition. What I am going to say, Mr. Lewis, is that in addition to all of the general conditions of probation, which are statutory and which you'll be receiving in writing, you may not remain at any assembly that has been declared to be unlawful. Now, that's already captured by the general condition of probation that you obey all laws. But I'm just sort of underlining it by saying when law enforcement has declared an assembly unlawful and you are there, at that point, a condition of your probation is that you must leave. Is that unclear to you, or is that clear?
I understand.
Okay, thank you. Thank you for the reminder, counsel. Mr. Hughey.
In imposing that special condition, Your Honor, is the court finding that that condition is reasonably related to the facts of the case from the trial court record, as well as the needs of a successful probation?
I am so finding. I find that the purposes of probation would be promoted by that, given the nature of the offense in this case. which, as demonstrated in the record, demonstrated, as the jury found, that Mr. Lewis engaged in riot, which would by definition be an unlawful group activity. Anything else for the record?
Just on that special condition, just for the record, that specific assembly was not declared unlawful at the time.
I agree.
Thank you, Your Honor.
Thank you. We'll go off the record. Mr. Lewis, I'm just going to ask you to, I'm sorry, Mr.
Notice and advice of right to appeal. I believe
that has,
that has to be provided, I believe now. So I want to put that on the record to make sure Your Honor gets a copy of that signed by defendant.
thank you. So, Mr. Lewis, you're required to be advised of your right to appeal in this case. There are time limits with respect to that. There's a form that we're going to present to you, have you look over with your lawyer. I'll ask you to, if you understand it, to sign it and give it back to me. That way I know that you have been advised of the rights that you have regarding appeal, which I understand you very well might be interested in pursuing in this case. So I'm going to ask you to hang around so we can get you the paperwork here and also get you that advice of appellate rights. Okay.
All right.
And I think that will do it for the record.
Your Honor, 3 days jail to be completed by November 1,
Correct. And Mr. Lewis may turn himself in to serve those 3 days.
but he will need to report to the sheriff today to.
To the jail, just to check in and to get whatever schedule organized. We'll go off the record. We are off the record. There used to be a weekend particular system. I don't think they're doing it formally.
Okay, so, yeah, I don't know, they might go back on the record after he gets the chance to look over and sign that paperwork. But, yeah, as far as, you know, the things that we've heard about, you know, him admitting to other stuff, you know, at this point, it's all in the past, unless it's like a murder or an arson charge. Statute of limitations has long since passed for misdemeanors, and most assaults the statute of limitations is 3 years. So, which is why I had said before that any of the other people who were present that day can no longer be charged because we're past statute of limitations. As being said, I mean, it does seem like the judge is definitely, you know, kind of taking this a little bit more serious than I kind of thought he would. Definitely don't have a problem with that in this case because, you know, this is a significant thing, and maybe this will be a splash of cold water on, you know, some of the people that have been involved in protests on both sides. You know, there's still a lot of outstanding cases from 2020 protests that ended up going as far as is he felon? Yes, he is technically in July when he was convicted. He became a felon. Today is just the day that a sentence has been set. You know, and theoretically, years down the road, he might be able to get this expunged from a record or, you know, some sort of reconsideration or something. I'm not entirely sure the process on that. But otherwise, you know, unless they go an appeal route and the conviction gets overturned, which to overturn a jury conviction, my understanding is the appeal has to be based on a error in the law, like the law was improperly applied during the trial. So it would have to be like some sort of evidentiary thing, or something that was objected to, but the judge overruled, and the judge was in error overruling that. They can't just say, well, we don't like what the jury said, so we want a different jury, or we want the appeals judges to look at it. It can't be for the conviction itself. It has to be from some of the other stuff. That said, I mean, while I still do question the validity or the benefit to him or to the community of him serving jail time, the 3 days, that the way the judge structured this, it both makes me feel kind of good about that, because there is something more than just probation, but that also, a day every other weekend, that kind of reminds me of like National Guard duty or something. You spend a weekend away from the house for something, and I'm sure Judge Souede was doing that to try to not impact his, whatever he's got with kids and partner and everything, as well as his upcoming job. Hopefully, I kind of hope that he does, something quick to, maybe get over 2 weekends this month, or just do a 3-day weekend thing, basically, and just get it all out of the way before he starts that apprenticeship. That's what I'd probably do if I was in his situation. But anyway, yeah, so I've been rambling for a little while now. It's been several minutes since they went off the record. If it is just paperwork, they probably won't come back on the record for that. So, since we're not seeing anything else, I'm going to go ahead and get ready to shut down the stream. Yep, you're welcome. Thank you all for tuning in, and everyone take care. Take care of each other. And while I know there's more cases that we have coming up to watch out for, let's hope we don't have too many more cases like this. Take care, and talk to y'all later.